Hello, everyone, once again. To those who don't know me, I'm Dr. Marcus Chi, a patent agent at NBS Intellectual. Welcome abroad to our mini IP talk. We are bringing you to Europe after China. So we're now in Europe. We are really happy to have our speakers with us. So before we begin, we will do an SOP, sound check. So can any one of you hear me and see me clearly? Please click the raise hand button. See this raise hand button at the bottom of your screen. Click it so that I know that you can see me and hear me. Oh yes, nice, really good. Okay, so we are really happy to have our two distinguished speakers from Kinon Legal Services. They will be with us this afternoon. Oh, it's a morning in the Europe. So good morning to our audience from the Europe and good afternoon to our audience from Asia. Right. So before we begin, let me introduce our speakers to you. So on your left is Miss Katerina Nicolaido. She's a founder of Kinon and state aid law expert. So she has a very extensive law and legal experience, right? And then she has been working in the DG competition of the European Commission. So, wow, it's so long. I'm not going to continue reading, so I'm going to stop here. Next, on your right is Miss Ekaterini Cornelia. She's an IP expert, intellectual property expert at Kinon Legal Services. She holds a master's in the intellectual property from Shanghai Tongji University, and she is an active member of the Europe Law Student Association. Also, she has been in the committee of the UN in New York and in the World Intellectual Property Organization in Geneva. So let us welcome both our speakers. Speakers, can you please unmute yourself and say hi to our audience? Hi.
Hello, good morning from Greece. Thank you very much, Marcus. Hi, everyone. Thank you for your invitation, Marcus.
Thank you, Miss Katerina and Katerini. We are really happy to have both of you here with us. So we are really looking forward to see your sharing. Yeah, so before we begin, let's have a brief chat. The COVID has been quite serious, especially in the Europe, United States, Brazil. So how has it been affecting the Europe situation there? And how is it like? How's IP filing there?
Coronavirus has affected, among others, the trademarks and patents registration. In each level, trademarks and patents were given an extension for the registration. I would like also to mention that at national level here in Greece, the registration of patents was increased, and that the significant interest of firms to register the trademark and the great importance for them to protect it.
All right. Yeah, so the situation has been quite bad because of this pandemic. Many industries has been halted, and even IP has been going downhill because of all these things, because businesses were really badly affected. So another recent heated news in the Europe is about Brexit, right? So we've seen that UK has left the European Union. So many have been wondering, how does this Brexit actually affect their IP protection in the Europe? So if people want to apply for a community trademark, for example, in the Europe, so how? It doesn't cover the UK anymore?
Yes, Marcus, you are right. The Brexit was the big issue before the coronavirus thing. Here in Europe, the United Kingdom formally left the European Union on 31st January 2020 and immediately entered into an 11-month transition period. The transition will end on 31st December 2020. What does this mean for the European trademarks and designs, and what about the patents? European trademarks and designs will continue to extend to the United Kingdom during this time. Businesses, organizations, or individuals that have applied European trademarks and designs which are going to the end of this transition period will have a period for 9 months from the end of this transition to apply to the United Kingdom. For the patent, we don't have any changes because, as I will explain after to my presentation, the European Patent Office is not an EU agency, so leaving the EU does not affect the current European system.
Okay, so in short, the Brexit has affected the trademark and design in filing in the Europe and the extension of UK, am I right? But there is a transition period. So if you would like to know more, please feel free to come and consult us after this talk. But patent generally is not affected by the Brexit. Am I right?
Yeah, you're right.
Okay, thank you to both of you for clarifying. So without further ado, let us proceed with the talk for today, the main topic. We're gonna explore why and how you should protect your IP, patent, trademark, industrial design, copyright, and so on in the Europe. So let's have Ms. Katerina and Katerini to enlighten us. The floor is now yours.
Thank you very much, Marcus. I will start. First of all, what is intellectual property? Today we will discuss about intellectual property. Intellectual property is a creation of human intellect and it's found everywhere, in everyday objects like cars, computer, furniture, in creative works like books and films. The brand that we choose to buy with a distinctive signs and features like our favorite athletic brands, Nike, Adidas. So, what are the types of intellectual property? Here, in this slide, you can see the types as the trademark, patent, trade secret, design, and copyright. In order to explain these types of intellectual property to you, I will use as an example the brand of Coca-Cola. I think all of you know it. In the first photo, you can see the trademark of Coca-Cola. A trademark is a sign that allows users and consumers to differentiate the products. Here is the trademark in English and Chinese. Right now, sorry for my Chinese. In the second photo, you can see the patent of Coca-Cola. Patent is a right granted to an inventor that allows them to exclude all others from making, using, saying their invention. Do you know the recipe of Coca-Cola? Neither do I, because it's a trade secret. The trade secret gives an opportunity to obtain an economic advantage over competitors who do not know or use it. So the recipe of Coca-Cola is trade secret, and I don't know if it's a myth, but a few people know about this. And the last one is copyright. Copyright is the exclusive legal right to reproduce, publish, sell, or distribute the matter and form of something, such as musical or artistic work. Here we have the advertisement of Bear and Coca-Cola during the Christmas holidays. I think you remember it. So, this is all the types of intellectual property. Intellectual property rights are territorial. What does this mean? This means that if you have a trademark in Malaysia or in Singapore, you don't have a protection in Europe. This is the reason we are here and we have to discuss about this. Why to enter the European marketplace? The area covered by the European Union is made up of 500 million consumers. Come on, that's 500 million potential customers that are split over 27 countries. Why should your company benefit from this market? So now, let's see how to protect your intellectual property in Europe. First of all, I will begin with trademarks. because a lot of businesses, they want to protect their trademark in Europe. In Europe, you can protect names, logos, colors, images, patterns, shapes, packaging of goods, or sound as trademarks. All these identify your products and distinguish your goods or services from others. Trademark registration grants its owner an exclusive right to use its trade secret in relation to specific goods and services in all member states of the EU. It's good, right? The trademark to be applied for should not be identical or similar to any earlier trademarks for the same or related goods or services. So it's really important before to grant a filing of a trademark in Europe to have a consulting about this in order to have a research into trademarks in the European Union. Here in this slide, we can see some examples of European trademarks like Adidas, Philips, Levi's. These are world trademarks because it's just a word. Other examples are, here as we can see, the shape mark trademarks or the pattern mark trademarks. Here we have a really luxurious brands like Louis Vuitton and Burberry. So, if you need protection in all European countries, you should register your trademark with the European Union Intellectual Property Rights Office. And you have a validation in 27 European Union countries like Greece, Austria, Belgium, Malta, Cyprus, Poland. We said before about the United Kingdom, right? That we have this transition period until the end of December of this year. Okay, we talk about the administrative center. Now, when should I file an European Union trademark application? The European Union Intellectual Property Office applies here the first to file principle. That is to say, the person who first files a valid application for a given trademark will become its owner. An applicant who has already filed a trademark application has a right of priority. A European trademark application for the same trademark in respect of the same goods and services within 6 months from the date of filing of the first application. So you have 6 months. So let's see what's going on in the case of refusal. In the case of refusal of trademark registration in one of the indicated countries, I'm sorry, you can't have a European trademark because the refusal will have effect on the territory of all member countries. A European Union trademark application may be opposed by any interested person within 3 months from the publication of a European Union trademark application. So we have 6 months from the date of filing of the first application, and we have 3 months for any interested person in order to oppose the trademark application. What about the validation of the European trademark? The European trademark is valid for 10 years from the filing date and can be renewed for successive 10 years periods and unlimited number of times. Imagine that Coca-Cola's trademark exists for 130 years, so you can renew it again and again. There is no limit for this. Here in the slide, we can see the whole process from the receipt of the application until the publication of the registered trademark. What about the official languages? The official languages of the European Union Intellectual Property Office are English, French, German, Italian, or Spanish. So, applications for trademark registration can be filed in any of the 24 languages of the European Union. However, a second language must be indicated as a possible language for opposition, revocation, or invalidity proceedings. This is that we suggest to our customers to start with the translation. It's really important. If we want to go through the Hellenic intellectual property offices, we have to translate it first and not just leave the application in Greek. Because it's more convenient from the next step of the proceeding. So, the fees for the European trademarks depend on the type of filing and on the number of classes applied for. Here you can see some fees below correspond to a filing application, which is the most affordable system of individual European trademarks. You can see here the basic fee, the fee for the second class, and the fee for 3 or more classes. And the currency is in euro. Okay, why to register a trademark in the European Union? What are the benefits of registering a European Union trademark? Come on, you have a single registration, filed online in one language, and is valid in all the European member states. The European Union trademark gives its owner an exclusive right in all current and future European member states, and the cost is reasonable. So you can enforce your trademark in a market of almost 500 million consumers. Do you remember that? We saw this in the previous slide. So before to move to another type of intellectual property right, please have in mind that trademark adds value to your company. Your trademark tells customers who you are. So let's move to another type of intellectual property right in European Union. What is a design? According to the definition given in the Community Design Regulation, design means the appearance of the whole or a part of a product resulting from the features of, in particular, the lines, contours, colors, shape, texture, and materials of the product itself and its ornamentation. The European Union Intellectual Property Office registered close to 85,000 designs per year. There are a lot, right? Here you can see in this slide some examples, like the packaging of the product, a product, composite products. What are the requirements for design registration in the European Union? Here we need 3 things. First of all, novelty. A design is considered to be new if it has not been disclosed to the public previously. Individual character. Assessing individual character consists of verifying whether the overall impression produced by the design differs from the overall impression produced by the design made available earlier. And the last one, it's non-functionality. Those features of the design that detected technical function do not receive protection. So we are talking now about the design. Here you can see the design of the logo figure. All of you know these toys, right? How to register a design? Again, the organization is the same. You have to file an application in the European Union Intellectual Property Office. This office is located in Alicante in Spain. So, What about the duration of the protection of designs? Registered community design is valid for 5 years from the day of filing. Do you remember? The trademark was 10 years and you can renew it unlimited. Here, the design, you have validation for 5 years and can be renewed in blocks of 5 years up to maximum of 25 years. This means that you have maximum 4 times to renew your design in the European Union. So what are the benefits to have a design here in the European Union? You have to file one application in one language of filing. The administrative center is the same, it's only one, and you have to pay once. So as you can guess, the procedure is simple if you think that you have a validation of your trademark in 27 European member states. So that's all for design. Now we will move on to another intellectual property right, copyright. What is copyright? Copyright protects literary and artistic creation such as poems, novels, music, painting, or films. Here I don't have to tell you so many details like the previous one because there is no formal registration process and copyright protections arise automatically upon creation of the work provided that it is original. Generally, protection lasts for 70 years after the death of the creator. And here I have some advice. Copyright doesn't protect the ideas themselves, but only the expression of ideas. This is about all the information that you have to know about the copyright. Okay, now let's move on to the last intellectual property right. It is the patent. What is a patent? A patent is an exclusive right granted for an invention. Its owner has the exclusive right to prevent or stop others from commercially exploiting the patented invention. So, what are the requirements for patent registration in the European Union? It's again the novelty, innovative step, and industrial application. Here I can give you some details what is not patentable in the European Union. According to the European Patent Convention, it's not patentable the discoveries, scientific theories, and mathematical methods, aesthetic creations, rules, and methods for perfuming metal acts, playing games or doing businesses, and programs for computers. Presentation of informations are not patentable too. The second set of exceptions include inventions contrary to morality, plants or animal varieties, and essentially biological processes for the production of plants and animals, methods for treatment of the human or animal body by surgery or therapy, and diagnostic methods practiced on the human or animal body, which have been excluded for social ethical consideration and considerations of public health. Don't be confused, the medicines and drugs can be protected under the patent. Maybe here you can see and listen to the news that some countries found or granted patent about drugs against to COVID. How to register a patent in the European Union? The European procedure begins at the European Patent Office. Your application is filed in English, German, or French. These are the 3 official languages of the European Patent Office. Once the application has been filed, an international novelty search is carried out. This search checks the application against the requirements of novelty, the inventive step, and industrial application. The requirements that I mentioned before, right? The European patent grant procedure takes about 3 to 5 years from the date of filing your application. It is made up of two main stages. The first comprises a formalities examination, the preparation of the search report and the preliminary opinion on whether the claim invention and the application meet the requirements. And the second involves substantive examination. So, by filing a single application for a European patent, you can obtain a patent in countries which have joined the European Patent Convention. Here, 38 states has been signed this convention. So there are not only the European member countries, but there are and other countries like Cambodia, Tunisia, Georgia. Consequently, the European patent is not a supernatural patent, but a bundle of national patents. This is the reason that in the beginning of our conversation, I mentioned that the Brexit doesn't affect the validation of the European patent in United Kingdom. So, how to search for earlier patents in the European Union? Before to grant your patent, you have to do a novelty search in order to find if your patent is to check your novelty of your invention. So, the European Patent Office offers the free of charge SpaceNet. You can see here in the slide. It's a database containing over 100 million patent documents. Here, if you want, for example, to search a patent for electric car, you can go up and write the keyword electric cars, and you can find the patents that are granted for the protection of electric cars in the European Union. It's really useful, and of course, it helps the technological institutes to find the prior art, what there is before to find something to do a new invention. So it's really good to use it. Patent protection is limited in time. 20 years from the date of filing of the patent application, it's in most countries. The patent may lapse earlier if the annual fees are not paid. So be careful to pay your fees, okay? Once the patent expires, the protection ends and anyone can commercially exploit the invention without infringing the patent. So here in the patent, it's limited in time. We have 20 years and we can renew it. How much does a European patent fees are charged for filing, search, designation of contracting states, claims, examinations, and grant and printing? Renewal fees are also payable for the third year and each subsequent year after the date of filing until a European patent is granted or until the proceeding have otherwise been closed. Here you can see the filing fee, examination fee, and fee for grant. There are another fees, but this is the basic one that you can check briefly. So, why file a European patent? As we said in the beginning of our conversation, patent rights are territorial by nature. This means that the protection is only valid in countries in which that patent is granted. Therefore, in order to obtain protection in different countries, one should either file individual applications in different national intellectual properties offices or to follow different registration routes. The European patent makes it possible to obtain protection in nearly 40 countries just by filing a single application. So the applicant just need to validate this grant decision in the countries in which the protection is issued. Therefore, a European patent provides applicants a less costly and a less procedural route in comparison with filing of individual applications. This means that if you want a protection for more than 9 or 10 countries under the European Patent Convention, you have to follow this route. If you need a protection only in Greece or in Germany, you have to go directly to the National Intellectual Property Office. And another benefit is that your invention will be examined for novelty and inventive step before the patent is granted. So you will know if your patent is strong. So thank you very much. Now we will continue with my partner, Katerina, and she will present to you some statistics about the European patent.
Thank you, Katerina. Let's see some graphics about the recent patent application in selected countries. The first graph shows that in 2019, the IPO received over 1,081 applications, 4% more than in 2018, according to the IPO data. What does this increase of patent application mean? The increase confirms that the European market remains key to the global economy's digital transformation. Please, let me help you. Okay, thank you, Katerina. Right. Okay. The second graph shows the geographic origin of the European patent applications filed with the IPO. The geographic origin of the file is determined by the country of residence of the first applicant listed on the application form, the so-called first name applicant principle. This was previously explained by Katerina. Can you guess which countries had the most applications? The percentage of the application countries are as following. IPO countries 45%, US 25%, Japan 12%, China 7%, North Korea 5%, and other countries 6%. The next graph, as you can see, shows the number of European patent applications filed with the IPO for the three technology fields with the largest number of applications in 2019. Which of the technology firms do you believe had the majority of applications? Let's see the interesting results. According to the data, digital communication show by far the strongest growth in patent applications, and as we can see, is overtaking medical technology for the first time in a decade. This reflected the pace of development surrounding 5G technologies. The second fastest growing field was computer technology due to artificial intelligence demand. What includes digital communication? The digital communication field includes, for example, amplifiers, decoders. In this field, there has been a substantial increase for several countries with large volumes of patent applications, in particular for China, 65%, the US, 15%, and South Korea, 36%. This shows that Europe is an attractive market for other actors and an actively innovating region. the field of medical technology covers medical instruments for diagnosis, treatment of diseases, and surgery. In the field, the top applicants in 2019 are the following: Johnson & Johnson, Royal Philips, Medtronic, Boston Scientific, Becton Dickinson. The last field of computer technology encompasses computer technologies such as computing, calculating, and counting devices. It includes, for example, digital computers and data processing systems. Top applicants in 2019 are Alphabet, Microsoft, Huawei, Intel. And the last one of the graph shows the geographic origin of patents that are granted by the IPO based on the country of residence of the first patentee listed on the published patent. The percentage of the countries that are granted patents are IPO states 45%, US 25%, Japan 16%, China 5%, North Korea 5%, and other countries 5%. From all the above mentioned graphs, we can conclude that the demand for European patents continue to. Before we examine some trademark infringement cases, let's see the jurisdiction system of the European Union and how it is divided. What does the Court of Justice of European Union do? The Court of Justice of European Union gives rulings on cases brought before it. The most common types of cases are: first of all, it is pretending the law, preliminary rulings. What does it mean? If a national court is in doubt about the interpretation or validity of an EU law, it can ask the court for clarification. The same mechanism can be used to determine whether a national law or practice is compatible with EU law. Second type of the Court of Justice European Union cases are those that enforcing the law, infringement proceedings. This type of case, it refers to cases against a national government for failing to comply with EU law. Annulling EU legal acts. If any EU act is believed to violate EU treaties or fundamental rights, for example, by any EU government, the European Commission, the court, can be asked to annul it, ensuring the EU takes action. The Parliament, Council and Commission must make certain decisions under certain circumstances. If they don't, EU governments, other institutions, or under certain conditions, individuals of companies can complain to the court. Action for damages. Any person of company who has had their interest harmed as a result of the action or inaction of the EU or its staff can take action against them through the court. The Court of Justice of European Union is divided into two courts. Court of Justice deals with requests for preliminary rulings from national court, certain action for annulment and appeals, and the General Court rules of action for annulment brought by individual companies in the same cases. EU governments in place. This means that this court deals mainly with competition law, state aid, trade, agriculture trademarks. An instrument of great value regarding the answers on interpretation and validity of Europe. Let's see some interesting cases. Who doesn't know Christian Louboutin and his red-soled high heels? Let's see the facts of the case. In 2010, Louboutin was granted a Benelux trademark for the color red of the sole of the shoe. In 2012, Van Haren, a Dutch shoe retailer, started to sell red sole high-heeled shoes. In 2013, the registration was amended, and suddenly the term shape covered only the high-heeled shoes and not the color. Louboutin take immediately action and initiated trademark infringement before the District Court of The Hague, and he won the initial procedure. On the other hand, Van Haren appealed this decision under Article 3 of Directive 2018-95 and argued that the mark at issue isn't protected as shape, which is limited to contours, measurements, and volume. The Hague District Court couldn't find an explanation of the term shape and asked the Court of Justice of European Union if the concept of shape includes also the color of the goods. On June 2018, the Court of Justice of European Union ruled that Christian Louboutin's red sole trademark was valid and opened the door for fashion brands to register colors as a trademark as part of the designs in the European Union. This case can be characterized as a landmark case for brands who use distinctive colors as part of the trademarks. While fashion is often considered a form of artistic expression, there are limited legal protection for fashion designs because fashion is inherently functional, regardless how fancy or expensive they are. Its main function is to keep us warm and clothed. Nevertheless, this decision by the European Union's highest court may encourage fashion brands to use colors, placement of color, and possibly combination of colors in order to distinguish themselves for the competition and imitate the ability for signature designs to be copied by competitors. The next case is Adidas versus Shoe Branding Europe. Adidas lost in the year's lost fight for its three-stripe trademark. The European Union General Court upheld the European Intellectual Property Office, Second Court of Appeals decision that the German sportswear giant's mark, which consists of three parallel stripes, lacks the necessary distinctiveness to be protected as a trademark. The General Court held that the sportswear brand failed to show that it is largely well-known mark had acquired the necessary distinctive character in order to be protected by trademark law. A trademark needs to be distinctive. Consumers should be able to recognize your sign for what it is as an indicator and as an indication of the origin. According to EU IPO, the card noted that a mark can be registered in the EU as a whole only if it is proof that it has acquired distinctive character through use throughout the entire territory of EU and its 28 member states country.
Okay. So, after all these informations, don't waste your time. Identify your intellectual property and protect it in the European Union. In this way, growing your business with intellectual property. Thank you very much.
All right, thank you very much to both our speakers, Ms. Ekaterini and Ms. Katerina. Thank you very much for your deep insights regarding EU. As we can see, for example, for patents, right? Currently, we have a lot of filings with regards to digital telecommunication technology, IT, computer technology, medical, yeah? So if you're in those industries, you know, in Europe, so application in those countries are very important. And as far as EU is concerned, Europe also has all these centralized body and organization for prosecuting your intellectual property protection in the Europe. Like we have the European Union trademark, we have the registered community design, and as well as the European Patent Office to do your patent filing and protection in the Europe, right? So as we can see, we've talked a lot about trademarks, patent, and ID, right? We have had some questions from the some of the attendees. For example, in the Europe, right? There are also, apart from the invention, the standard patents, right? We also have small patents. Sometimes we call it petty patents, right? Or utility model. So does the EU accept application of the utility model?
First of all, thank you very much for your question. I want first to explain to the audience what is a utility model. Model is an exclusive right granting for innovation. As you said, Marcus, it's similar to a patent. It's sometimes referred to as a PT patent or an innovation patent. It can be granted to anyone who invents or discovers a new and useful machine, article of manufacture. But unfortunately, utility model does not exist in all European member states. Here in Greece, we have a utility model. So the utility model protection cannot be obtained at the European Union level. So we don't have a system that protects the utility model across the European Union member states.
I see. So to distinguish between the standard patent and small patents, only the standard patents can be filed in the Europe, right? So for the small patents or utility model, they have to go into individual countries that have that system. So we cannot go through the centralized route. Am I right?
National level, yeah.
Yeah. So trademark is one of the very widely registered mechanism in the Europe. Like we have a European Union trademark. So how long does it normally take for it to be registered there?
Okay, the European trademark registration takes up to 4 to 8, 9 months. I will explain again the registration process to you. You have to file one application. Then we have the examination of application. This period lasts 2 to 6 weeks. Then we have the application is published. And if you remember, I mentioned in my slides that the opposition period starts and it lasts 3 months. If no opposition files, the trademark is registered. And of course, after this, we can renew it. So generally, the registration takes up to 4 to 8 months. in order to have a European trademark, a European Union trademark.
I see. So is the trademark protected in all EU languages? Like just now you've mentioned 4 languages. So how does it work? Like if I were to file an English application for the EU trademark, and then how does it work? Do I have to translate them into the other 3 languages or what?
Oh, this is really good and difficult question. Thank you very much. First of all, there are 24 official languages in the European Union. So I imagine there are a lot of different expressions of the same idea, think element. For example, in English we say apple, in French we say le pomme, and in Greek we say milk. It sounds so different, but the meaning is the same, you know. So generally, there is no clear-cut answer to this question, as most disputes and legal suits are solved on a case-by-case basis. So no exception in this similarity of trademarks. Evaluation criterion to be taken account when evaluating the similarity between the marks in different languages are similarity between the marks. As we can know, marks are always compared visually, orally, and conceptually. If the comparison is favorable, there is similarity between the signs. And another criteria is the confusion of the customers. We know this, that the court, if they want to see that the trademarks are similar, they start a research and they ask the consumers if they understand the difference between the 2 trademarks. So this is the answer. I think to understand.
Okay, thank you. So if anyhow, we just have to file 1 language into the EU IPO for the EU trademark, right?
Yeah.
Okay. So for the attendees out there and those audience watching our live on Facebook, you can actually ask your questions if you have any, and we will have the speakers to address your questions. Let's see. All right. Any other questions from the participants? No? Okay. We've talked a lot about patent designs and trademark. So trademark is one of the very famous element of the IP, and it's the soul. Trademark is the soul of your brand. Am I right? So you do branding, you must have a name or a logo or a mark. So next upcoming, we have a talk by our senior legal advisor. All right, so the do's and don'ts of trademark. So what trademark owners or brand owners should be wary of? What you should be careful when you design your mark, and how you should get your trademark protected. So our talk will take place on the 28th of August, next Friday. It's happening soon, next Friday. So please register for this talk. It will be by our senior legal advisor, Mr. Anthony Tay. He's a very expert and experienced trademark expert in this field, yeah? So please register if you would like to know more about trademarks and how to be wary, what aspects to be wary about, yeah? So if you have any question, you can actually surf our official website, www.nbs.com.my, and go into our Facebook, NBSMY. You can also leave a question there, right? If you have any query, please follow. And also, if we have any events coming up in the future, it will be posted on our Facebook as well. So please like and follow the page, yeah? So with all due respect, this talk is coming to an end, yeah? If you have any questions, please approach us with your inquiry. Let us once again thank the speakers, Ms. Katerini and Katerina, yeah? We are really happy to have you with us this morning or afternoon in Malaysia. Right? Thank you once again. Have a nice day.
Thank you very much. Goodbye from Greece.
Bye.
Thank you.